Hey doing guys, Paul here from Family Separation Services. I've just wanted to do another video as promised in relation to access. I done one on maintenance the other day in relation to COVID-19 and how to implement it, and I suggest you have a look at that. And I said I'd do another one on access, but I held off for a couple of days because I wanted to see was there any statements coming from the government or the court service, and long and behold something came today. So first of all, I want to go through specifically what was said. So the Irish Independent put an article up today. I placed it on the Family Separation Services page, and it came with a statement from the Department of Justice having corresponded with the court service. Okay, and basically, sorry, I just have it noted here. Okay, so the Irish Independent today reported the Department of Justice told the paper that as things stand, court orders must be adhered to, and they were informed from the court service that this is their position. Okay, so that was earlier on today. Keith Walsh and the FLAC, Free Legal Advice Centres, have indicated that they've been inundated with calls regarding issues with access orders and implementing them, and so on and so forth. And I too have been inundated with calls and texts and messages on Facebook and so on. Okay, the paper went on to say a government source told the paper restrictions in place in Ireland do not stop children seeing their parents. Okay, the court service said they're deciding how best to provide information on queries relating to enforcement of court orders in the context of the current social distancing situation. Okay, Keith Walsh's view is that access should go ahead provided social distance rules are maintained by parents and provided there is no inherent vulnerability on either side. Now there's the grey area, inherent vulnerability, because everyone's going to have their own view on what inherent vulnerability is, and that's where the problem lies. Okay, there would need to be a really strong medical reason for access not to go ahead. So that's just Keith Walsh's view. He's the chair of the Child and Family Law Review Committee in the Law Society of Ireland. Okay. The problem is, because the courts are all over the place, breaches are going to take months to be dealt with, and obviously where possible parents should work together. But obviously, as we've been talking recently and the messages I'm getting in, that's clearly not happening. Okay, now just before I come on to do this video, the president of the district court has issued a statement in relation to family law matters, and I'm just going to go through there with you. First of all, the court's offices, while they remain open, they're only providing a service at the counter for urgent issues. Okay, anyone who wants to drop documents in or whatever, they have a drop box outside, and anyone they're prioritising domestic violence issues. Okay, but he went on to say that there's a practice direction there today. So if you go on the court's website, courts.ie, there's a practice direction issued by the president of the district court today, and you can read it in full. But the gist is, if anyone has any applications or issues they'd like to make to the court that don't fall into the urgent category, they can email the district court where their order was made, or the circuit court, highlighting their issues and queries, CC your ex that you're making this application, and the court will come back to you with a response to deal with individual issues there where you consider it to be urgent or important. Okay, and the courts will come back to you there. One of the other things they said was the best outcome for children is for parents to contact each other to set out their concerns and suggest ideas for practical solutions that can be put in place. The health concerns of parents, their children and extended family need to be considered when sorting out arrangements. Now that's what I said in my previous video. Common sense must prevail. We have court orders. Court orders must be followed. However, health trumps justice at the moment. But then don't milk it. Don't be acting the billy goat, using the virus as an excuse. So again, I know there's grey areas. We've had lots of people contact us from various. We've had parents who don't live with the child complaining that the parent who lives with the child was stopping access just for self-isolation reasons, but then wasn't going to get a test around, was just having self-isolation reasons for the purpose of access. Then we have people who do live with the child where the other parent who takes access is refusing to take access because of their own people they live with and so on. And some, it's hard to gauge you know, what's right and what's wrong. You know, some people are saying I'll take access, but you have to let me have the child for the whole time, because every time I give you the child back, I've got people in my house with underlying illnesses. So either give me the child and I'll take the child full time. And obviously, the parent who the child lives with is fearful that how long is it going to be before I see the child again. And then we've got the domestic violence issues. And I always say I'm not talking about any individual cases. I'm talking in general, right? I know there are exceptions, domestic violence cases, where there's coercive control, you know, and where people have ordinarily been controlling, and now this just provides an extra tool to enhance that control. And I do get all that, and that's the problem. There is no straight answer, okay? The courts, the President of the District Court goes on to say, as parents, if you agree that the arrangement set out in the court order should be temporarily varied, you are free to do so. Make a note of this agreement by way of email and text message. Again, in my last video, if it's not wrote down, it didn't happen. Operate while you're protecting the best interest of the child and the people around you in decisions you're trying to make. Don't be overprotective, but whatever decision you do make, remember you're in breach of the order until such time as a court says otherwise. And if this eventually does go to court for breach of access, the evidence you provide, where you communicated early, you weren't being unreasonable, you know, there was logic in the decisions you were making, and you were communicating those effectively. The only way you can prove that is by text message or email, preferably email. It's more formal, you can print it out. Okay, they go on to say, where a child by agreement does not, by agreement they specify, again they don't want to say breach an order, okay, where a child by agreement does not get to spend their usual time with their parent, the court will expect the contact is established and maintained regularly. Using video technology such as Skype, Zoom, WhatsApp or FaceTime might help, and if this is not possible, telephone conversation should be arranged. So again, there's no reason, like I said in my previous video, that contact can't be adhered to in some way, shape or form. And again, that's going to make the difference down the road when you go to court. That, you know, I've had people say, you know, they don't have time to facilitate access, or the child doesn't want to. You know, now a 5-year-old child saying they don't want to talk to daddy or mommy on the phone, like, you know, sometimes are we going to do what the child says? Does the child need to be encouraged? Because if the child also said to you they don't want a bat, are you not going to give them a bat? No, of course you are, because the child's welfare and well-being is more important than the child's wishes on some occasions. So we can't just pick and choose when it suits us whether we're going to listen to the child or do what's best for them. And we all know what's best for children is to have a loving, caring relationship with both parents where possible. And I emphasise where possible. I know cases are different. So these current restrictions mean that the detail of every access order may not be fully implementable, but as parents you should make every effort to allow your child to continue access in a safe and alternative way. It is not always possible for people to make these changes without help. So, you know, there's different organisations you can go, but obviously you can contact us, okay? Now, so between the Irish Independent today, obviously the Independent contacted the Department of Justice to make a statement, and they made it an off-the-cuff statement. Then they get onto the court service, and now the President of the District Court has issued a practice direction and has made these statements. This is what the courts are going to base any breach applications on. Did you adhere to that? So have a look at it on the website, okay? So just like my maintenance video, the same with access. Whenever you go against the court order, you are in breach of the court order. But like normal times, if there are situations where the situation was beyond your control in breaching it, or that you made a logical decision in the best interest of well-being of the child without being overprotective, without, you know, because the secondary evidence is going to make or break how this looks when it goes to court. Follow the practice direction. There's no reason Zoom, Skype, WhatsApp, FaceTime can't happen. There's none. And you can't blame the coronavirus on that. Okay? So again, communicate all the time. Okay? We've got loads of issues coming in. I can't tell anyone to break a court order. I can't give direct answers because with the limited information you give, I don't know the full circumstances of your case. All I can do is give guidelines in accordance with court service statements and government statements. And if, you know, like everything in this coronavirus situation, it's going to be fluid, right? So there might be new information next week. and there might be new information the week after. Okay, like every sector in society, we got to be adaptable with change, but do not, please, I keep saying it, the court order is just a guide, as in the court can't solve every single incident that occurs. Okay, you know, you can't control what the other side does, you can only control how you react to it. Two wrongs don't make a right. Just follow the principles, but don't be too strict. Please don't be too strict. You know, like if someone has an underlying medical issue, the kid can't go there, okay, in that house if there's someone with an underlying medical issue. If there's someone with, if there's an elderly person, if the person goes for access and the parent who gets access lives with their parents or elderly people, obviously access can't take place there because you're putting these elderly or vulnerable people at risk. You know, yes, you're breaking a court order, but that's your reason, right? But there's no reason, even if it was meant to be overnight access in situations like this, that you can't come and collect the child and go on a walk in the park. Just adhere, as I've said, adhere to the rules on social isolation or social distancing and so on. Like, common sense. You know, you got to put your differences aside. I keep saying it. You know, it's still going to get more worse before it gets better. They're only preparing for the chaos before it happens. Now's the time to make a plan with your ex. I know you can't stand each other on some occasions. I know you don't talk. And everyone's ringing saying they're just using it as an excuse. And maybe they are, but two wrongs don't make a right. If the logic of what they're saying makes sense, even if it is just an excuse, go with the logic. If it doesn't, as I said, if there's real severe issues, email your local district court where the order was made, highlight your position, CC the other side, and wait for the court to respond. If you have any more questions, send them in to me. If I get any more updates, I'll do more videos. But the one thing I will tell you is we've 15,000 likes on Facebook, okay? But Facebook and all their madness, even though I got 15,000 likes, I need to pay to make those 15,000 people see it. So I need you all to share this video and my other videos. When you go on my Facebook page, you might have liked it, but you've also to click over the like button and click follow to get notifications for every time I put up these videos. It might be easier as well that we've got a YouTube channel, Family Separation Services. If you subscribe to the YouTube channel, you will get notifications each time we put up a video, because I think I'm going to be doing a lot more videos on this as time goes by than I've ever done videos before. So with the maintenance, it's a court order unless you can pay it, or unless you can show you had a significant loss of earnings and send the ex the letter from your employer showing this, that they may need it to bring to the social welfare to help with their payment if their means tested, okay? Don't let them just find out the money didn't go in. Communicate. Emails, text message, you know, work together here. With access orders, go ahead. You're in breach if you don't. But later, if you can show a reasonable explanation and you facilitated video chat or whatever, you didn't just cut off access, just like you don't cut off maintenance, even if you've had a reduction in earnings. I said about maintenance, even people on social welfare payments make a contribution. So there can never be a situation where there's no maintenance, and there can never be a situation where there's no access, no matter what virus is going on. So that's not an excuse. It's not a reason. Work together, please. I know domestic violence cases make it even more difficult, but the court will say, like, if sometimes the courts make a barn order and a safety order, but they also make an access order with it. So if the courts were happy enough to make an access order, even though there's a barn order and safety order in place, you can't really say access has to stop now, because nothing's changed from the perspective of the order. You know, if there was no access, if access wasn't safe or there was an issue, the court would have made that decision at the time of making the safety order and the barn order, you know. But I do know people like to be controlling, and I know people like to manipulate the situation, and sometimes people who are victims of domestic violence, you know, suffer more in these situations, especially for people who live in the same house under the same roof while they're separated. Again, contact us. Email the court. You don't have to be seen to be doing this, you know. Send us a message if you can't talk, you know. We will get back to you. All right. So Family Separation Services on YouTube, subscribe. Family Separation Services on Facebook. Don't just like, you gotta follow if you want to keep up to date with everything. info@familyseparations.ie for email, and you can contact us on the office 01 412 4456. Please use your common sense. Please don't milk this situation. It's going to get worse. People are going to get sick. Loved ones are going to get sick. Let's try and stop the spread of this virus. Let's comply with our court orders as much as we can. And if in doubt, send us a message or email the court with your position and they'll respond to you. Now, don't expect them to respond tomorrow because they are up to their eyes, but they will respond. Let's just work together here. Let's put our differences aside, okay? And I will be in touch with more videos soon. Thank you.